I have had adversaries, prosecutors, on rare occasion joke and say, I only did it because you were being too effective.
Right.
But even joking, I bristle when someone objects during my arguments, and I would never do it to an adversary. And listen, they can try to throw me off my game or whatever. I do remember once giving a 2-hour sentence in a very important case here in Bergen County, and the fire alarm went off in the middle of my case. 1 hour in my summation. We all had to go out, vacate the courthouse, or outside for 2 hours. And
it wasn't an arson case, was it, John?
It wasn't, as a matter of fact. But when I came back, you know, I told the jury, I said, we were talking about circumstantial evidence before. I said, and I'll tell you this, I said, first we talk about motive. Who had a motive to interrupt my summation? I looked over at the prosecutor. Who would benefit by my summation being interrupted? I looked over at the prosecutor. Now, I'm not saying circumstantially the prosecutor pulled the fire alarm. Well, the jury went hysterical laughing. We had a very good time, and I immediately got back on track. So if you're interrupted by your adversary, you should think in advance, as a comedian does, how to respond to hecklers. And you should respond in such a way so you turn that supposed negative into a positive. And there's lots of positive ways to turn that kind of interruption into a positive. Because after the judge, for instance, overrules that objection, you then simply just turn back to the jury. And remember, if it's not a videotaped courtroom, you can do anything you want as long as you don't say it. And you just look at them, sigh, and then move on, as if this was just an unfair tactic. That sigh and that pause to the jury will let them know the prosecutor just been unfair.
What's your experience in terms of how juries react to this when they're kind of following along what you say and there's an objection? I mean, tactically, do you think sometimes it's a mistake to do it?
I always think it's a mistake to see.
No, I mean as a matter just not for you personally, but just as a general proposition.
Jury studies suggest that two things that are surprising, and all attorneys should know this. Number one, the attractiveness of the client plays a huge part in the outcome that will be obtained. Numerous studies trying the same case, an hour-long case in front of lots of juries, but substituting a more attractive male or female client for a less attractive one. That the more attractive the client, the more likely your client is to get a better result in that trial, and that's the truth. But number two, the second study indicates that the more the jury likes the attorney, the more likely they are to rule in favor of that client. So to the extent that relying on those jury studies, it's always been my premise that you have to make yourself